why you should conduct a trademark search before you file and form your LLC, and the 5 levels of trademark protection. I'm Queen, the Veiled Lawyer with Belter Law Firm. So, why you should conduct a trademark search before you form and file your LLC with whatever Secretary of State department that you choose to file your LLC is because the trademark office and each Secretary of State department, they do not communicate with each other. So theoretically, you can file for an LLC, a name. So say for instance, the name is going to be Buds and Bubbles LLC, filing that in Louisiana, and it goes through. That does not give you any type of trademark protection. That does not protect the name of Buds and Bubbles whatsoever, because the Louisiana Secretary of State is where you form that LLC. In the United States Patent and Trademark Office, they do not communicate at all. So there could be somebody else in the rest of the states with a LLC named Buds and Bubbles LLC, and there also could already be a registered or pending trademark for the Buds and Bubbles brand name. So you do not know if your chosen business name or brand name has already been trademarked or if there's a pending trademark application. So that is the biggest mistake, one of the biggest mistakes that entrepreneurs and business owners make, is they go ahead and they file their LLC before they conduct a trademark search, because most people, the name that they choose for their LLC, they do use that as their brand name. So I always advise my clients, I do not file an LLC before I conduct a trademark search for that name. I don't do that at all. Okay? So that is why it is important to conduct a trademark search for the brand name that you are going to use before you file for an LLC. So what happens if you conduct a trademark search and you find that the name that you want to use for your LLC is already trademarked, or maybe you have already filed and formed your LLC and you find out that that name is already trademarked? Theoretically, you can still use that for your LLC name, but if it is already trademarked, if there's already a pending application, you can still use that for your LLC name, but you will have to change your brand name. So your brand name and your LLC name in that instance can be two totally different things. You would just have to do a DBA, doing business as, and then trademark your brand name. Or you can just go into the Secretary of State and do a name change there and then utilize the name that is clear and free. So when it comes to names, what are the 5 levels of trademark protection when it comes to names? So there are levels to this, y'all. Some serious levels that come with choosing a name that you intend to trademark, well, that you need to trademark. Because if you're doing a brand name, if you trying to be on any grand scale, you're going to have to get a trademark. But what increases your chances for you to have a name that will maybe not have an office action, or if it does have an office action, it will be able to be overcome? That's when you look into the 5 levels of trademark protection. So at the top of the pyramid, that is the highest level of trademark protection. That is called fanciful language. That is a word that is either made up, a completely made up name, or is an actual word, but it has absolutely nothing to do with the goods or the services that you have within the stream of commerce. And so the second level of trademark protection is arbitrary. And then that is an actual real word, but that technically has nothing to do with your goods or services that you're selling as well, but it is not necessarily a made up name. Then you have what is called suggestive. That is the third level of trademark protection, and that is a name that actually is suggestive of the goods or services that you have within a stream of commerce. Then you have what is called descriptive, the fourth level, which you can get a trademark for, but you really don't have a solid trademark protection, even if that descriptive name does go get registered. It may go to the principal register. More than likely, it may go to the supplemental register, but it literally means that it is describing the goods and services that you have in the stream of commerce. And then you have generic. Generic brand names, they get no trademark protection. So what is a fanciful name? So the best example is Kodak. So you have Kodak for photography, they do printing and all of that. Technically, you can say that's a real word, but for the sake of this video, it is fanciful. And Kodak has absolutely nothing to do with photography or printing, nothing to do with that whatsoever. I think there may be a town in Alaska called Kodak, but essentially, for the sake of trademark protection, that is at the top of the chain, and that is considered fanciful. So nobody will be able to, use Kodak for anything dealing with photography, printing, anything, technology, anything like that whatsoever. So Kodak, they have that on lock. So the second level, arbitrary. Best example, Apple. Computers. Everybody's Apple. I'm Android, so y'all know how that war goes. Apple versus Android. But Apple, that falls under the arbitrary category. And apple is a real word. It's a fruit. It is actually a common word. United States, we all learn A is for apple. But Apple has absolutely nothing to do with computers or technology or anything of that nature. Then you have suggestive. So what a good example of suggestive would be is if you are selling refrigerators, coolers, ice chests, and your brand name is Penguin. A penguin lives in a cold environment. A refrigerator, an ice chest, cooler, keep things cold. So that brand name of Penguin, that is suggestive of the products that you're selling, because obviously if you're selling refrigerators, ice chests, and coolers, you want to have things in a cold environment and keep things cold. So fanciful, arbitrary, and suggestive, that is the sweet spots that you want to use when you are choosing your trademark name, your name that you're going to trademark, your brand name, okay? Then you have descriptive. Descriptive is literally what it means. So say, for instance, you have a pizza shop and you name it Cheesy Pies. That is descriptive. And I do not recommend descriptive names at all. You can get trademarks for that. Cheesecake Factory is a good example. Okay? But it just really depends. I don't suggest descriptive names at all. Then you have generic, which you will not get trademark protection at all. So, for example, you are a cosmetologist and you literally name your hair salon The Salon. That is not going to work, you all. So you always want to keep that in mind when you are coming up with your brand name that you are going to get trademarked. You want to conduct a trademark search before you file and form your LLC. And then you also want to choose a name that either falls within fanciful, arbitrary, or suggestive. Those three levels, the top three tiers of the trademark name protection pyramid, fanciful, arbitrary, and suggestive, that is the sweet spot that you want to use in order to choose your name that you're going to use, okay? So I am Queen, the Veiled Lawyer with Bell Terra Law Firm. Don't forget to comment, like, and definitely subscribe. Thank you.